Hello, everyone. This is Haley Hansen. I'm the leader of Husch Blackwell's Higher Education Group. We are excited to have you with us today as we talk about basic requirements of the Foreign Corrupt Practices Act, or FCPA, and how colleges and universities can remain in compliance and avoid common missteps. Before we begin, I'd like to cover a few housekeeping items. At the bottom of your audience console, you should see multiple application icons for your use during today's program. I'd like to take just a minute to highlight a few of those for you. First, if you have questions during the webinar, please submit them through the question box, and we'll try to answer your questions during the webinar. However, if a fuller answer is needed or if we run out of time because I tend to be long-winded, we will send you an email later this week and make sure we answer your question. We truly appreciate audience participation and do encourage you to submit any questions that you have. There is an icon at the bottom as well that lists your viewing preferences, and so you can expand your slide by clicking on the maximize icon at the top of the slide area, or on the top of the slide area, or by dragging the bottom right corner of the slide if you need to make it larger. If you have technical difficulties, please click on the help icon. It has a question mark and will provide you common answers to technical issues. A copy of today's slide deck and additional materials are listed in the resource icon that looks like a folder at the bottom of your screen, so feel free to print off a copy of our materials. This program has been approved for Colorado, Illinois, Iowa, Missouri, Nebraska, Tennessee, and Wisconsin continuing legal education credit. Texas credit is still pending, but we have submitted it for Texas as well. To report your hours in Illinois, Nebraska, or Tennessee, you'll need to click on the COE icon at the bottom of your screen and complete the questions. It's very important that you have your bar numbers to submit, and that also you do this before the webinar concludes. So again, from Illinois, Nebraska, and Tennessee, please click the COE icon. A recording of this webinar will be available tomorrow for watching and sharing internally at your college or university. Once available, it will also link you to a certificate of attendance. So with the housekeeping matters out of the way, let me introduce my co-presenter today, Lisa Parker. Lisa is located in our Chicago office and really focuses her practice on counseling and representing higher education institutions in the areas of accreditation, regulatory compliance, risk management, litigation, and student-related concerns. So I'm very happy to be presenting today with Lisa. So with the introductions out of the way, let's go ahead and get started. Our agenda today, again, as we put in our description of this presentation, we are going to take you through really the basics. So the Foreign Corrupt Practices Act has a lot of moving parts to it, and we want to take you through the basics so somebody who really hasn't dealt with this much can understand what is required, what are the compliance obligations, and what do we see really as the pitfalls that colleges and universities can fall into. So we're going to talk about the purpose and scope, enforcement of the FCPA, and also then wrap up with compliance. So as we talk about the Foreign Corrupt Practices Act, I think it's really important to understand that higher education has really increased its global enterprise. In the past, we would only really see study abroad programs, and now we're seeing increasingly that schools are starting to have campuses overseas or other satellite locations. They're having collaborative efforts with other institutions. All of these things are happening quite frequently amongst large and small institutions, and therefore really increases the need that schools understand the requirements of the Foreign Corrupt Practices Act and what you can and cannot do under that act. So some examples of these activities that are subject to the FCPA. Interestingly enough, I mean, we know obviously that this was an act that was put in place regarding anti-bribery, but a lot of the times these some of the FCPA violations that we've seen come back to obtaining licenses or permits for different types of buildings or structures or programming, all of those types of things can be subject to the FCPA, which we're going to talk about in detail. Obviously, there's other types of activities that's subject to as well, including if you have research projects in a foreign location, if you host a foreign official, that could subject you to the FCPA, and we'll talk about the parameters of that as well. Interacting with foreign officials regarding student visas, and particularly we think this could really increase and the volume as we've seen some of the immigration issues that have happened during the first part of the Trump administration. It is likely that foreign countries, as they're issuing visas for students to come to study in the United States, that we could see an increase in compliance in that area to make sure that there aren't any types of bribes or any types of gifts or exchanges that occur to get you to the front of the line for that type of visa. So we're seeing a lot of these types of examples that fall subject to the Foreign Corrupt Practices Act. So let's take you back to when the Foreign Corrupt Practices Act went into effect. That was, it was implemented by Congress in 1977, and really there were a lot of different bills that were proposed, 7 in total, that were actually proposed to try to identify this issue that Congress was focusing a lot of its attention on. There were companies, specifically Lockheed Aircraft Corporation, Gulf Corporation, to name just a couple, Ashland Oil, Exxon Corporation, and each of these, there were allegations in the 70s that there were payments made directly or indirectly to foreign officials in connection with a business purpose. And so the government was trying to figure out how are we going to respond to this, and ended up passing in January, I'm sorry, not in January, in 1977, ended up passing the Foreign Corrupt Practices Act to halt these types of practices, to create this level playing field for all businesses, and to restore public confidence that was waning at the time. Since 1977, there was not a lot of enforcement, honestly, of the FCPA. We didn't see a lot of actions. There were very minimal amounts of enforcement in this area, but we saw a start of the enforcement during 2006 in the Bush administration. They started to enforce more through the Department of Justice, and actually the SEC as well. They had more enforcement actions, and that really has ramped up in the last few years as well. The posture under the Trump administration is still fairly unknown, but likely there's typically less enforcement with smaller government, which is what's been proposed through President Trump's new budget. So we may not see as much enforcement, but again, we saw the ramp up start during the Bush administration. So what are the basics? The Foreign Corrupt Practices Act has really 2 components. The first component is what I already talked about earlier, the anti-bribery provision, so that you cannot directly or indirectly bribe or provide a gift or payment to someone for a business purpose. And that actually applies to not-for-profit entities. It applies to anyone, the anti-bribery provision, as you're doing business in foreign countries, or, as I said earlier too, hosting foreign officials in the United States as well. And then the second component of it is the record-keeping provision. The record-keeping provision is for publicly traded education companies, and it's important to understand that they are required to maintain accurate books and records and create an internal accounting controls to ensure that transactions and payments are properly authorized and that they're reasonable for any foreign transactions. So that's required for publicly traded companies. It's not required for not-for-profit institutions. However, in order to show compliance with the FCPA, it is a best practice to have those record-keeping provisions in place as well. And I'm going to talk about that later as I talk about your steps to compliance and what you should be looking at your institution. All right. So the anti-bribery provisions under the FCPA, the federal government can pursue criminal and civil actions against an offender. These are the elements that must be proven for the anti-bribery provisions, but Lisa's going to really go into them in detail. The last two bullet points in which somebody has knowledge and with a corrupt intent are extremely important when you talk about either civil or criminal actions that are initiated, and specifically for the corrupt intent that you have the intent, we call it in the legal profession mens rea, the legal aspect where you have almost a guilty mind, and so that intent has to be shown as you go through the criminal or civil proceedings. So with that, Lisa, I will turn it over to you to talk about the scope of the FCPA.
Okay, thank you, Haley. So we're going to talk about the scope of the FCPA and discuss it in very broad terms, just to sort of give you a basic understanding of the Act. And we'll go through each of the elements. But first of all, just for a starting point, the FCPA is extraordinarily broad, which is important to understand. So it covers both your institution as well as individuals. And so that means it covers those that work for your institution, such as faculty, staff, coaches or administrators. So it covers everyone who's employed by your institution, and it also covers your governing board. But one of the areas that's actually the most problematic in this area is that the Act also covers your institution's third-party agents. And that means those who are working on behalf of your college or your university. So in particular, if you are having dealings overseas, this could mean your venture partners, it could mean consultants, attorneys, contractors, or just your business associates that you're dealing with when you're working overseas and in a foreign country. And one of the reasons that third-party agents are so problematic is that when you are working in a jurisdiction that you're not accustomed to, you really rely on these third-party agents to get the lay of the land. But because they also could subject you to liability, it's very, very important to make sure that you properly supervise those agents abroad. So then, now turning to the actual elements of the FCPA. So as Haley mentioned, the Act is an anti-bribery provision, so it really focuses on corruption. So it only applies when someone acts corruptly. And this means that either the covered person or the entity must be acting in a way to attempt to influence a foreign official to misuse his or her official position. So that's the first piece of it. The second piece of it is that it only applies, or it's only implicated when someone acts corruptly by offering or making or authorizing the payment of anything of value. So for example, if someone at your institution offered a monetary bribe to a foreign official in an effort to get that person to, let's say, select your institution for a foreign grant, that's the kind of thing that would come under the FCPA. But one of the things that's really important to keep in mind is that the FCPA applies even if in that instance the bribe wasn't successful. Even if the other person did not accept the bribe, just the fact that someone was offering that would allow it to come under the FCPA. So it's very important to make sure that you're carefully scrutinizing your activities abroad. So again, as we were saying, the focus really is on corruption and making sure that that it only applies when someone's acting actually corruptly and is attempting to really use their influence. And so in terms of what they can give, it could be anything of value. And that really covers a wide range of things. It includes cash, entertainment, travel. So it's not just something that's actual monetary. It could be gambling. It could be travel expenses, gifts, property, discounts, giving to a foreign official's favorite charity, or giving a job offer, let's say, to a foreign official's relative. So anything of value can be covered by the FCPA. So one of those things could be gifts. And so one of the things that is possible, especially if you are operating in a foreign country, is that oftentimes in different countries it's customary to give gifts. That is just part of the overall example. So when you're overseas, this is something to really think about. So this could be a nominal gift, something that's just customary. There's also no limit on it, so there's no de minimis threshold, so even a $1 gift could potentially be subject to the FCPA. And just because it's something that's customary in that country, that does not make it a defense. It still could be covered by the Act. But it's important to remember, though, that a gift could be okay as long as you do not give it for a corrupt purpose. So you're not giving it for the purpose of influencing an official. So generally, if you gave, let's say, something that's a very nominal gift, such as just a logo, something with your institution's logo on it, let's say a sweatshirt, as a one-time gift, that probably would not be a problem. But it becomes a problem when the gift is expensive and when it's ongoing. And so one of the best examples of this was that the liquor company that produces Johnnie Walker and Smirnoff liquor brands ended up entering into a $16 million settlement with the government. And the reason for that was, in part, it covered many things, but in part it was because they were alleged to have spent over $64,000 on rice cake pedants. And these were customary gifts given in Korea that they were alleged to have given to Korean officials over many years. These were not huge dollar gifts, but they ranged from $100 to $300 that they were giving to military officials, and those were the officials who were responsible for obtaining liquor for the Korean government. So it was the fact that over time they were giving these rice cake gifts and giving them gift cards and things of that nature that ultimately led to them having an FCPA problem. So just as an example, here's a hypothetical, and we're going to do a poll question for this. So through a joint academic program located in a foreign state, Dean USA and Dean Foreign Soil University, FSU, develop a strong working relationship and friendship. During the course of their work, Dean USA learns Dean FSU loves soccer. After a successful first year of the joint program, Dean USA gives Dean FSU soccer tickets to enjoy during his upcoming trip to the USA. Is this a problem? So you'll have the opportunity now to respond to this. The question is, so is Dean USA violating the FCPA? Yes, no, or it depends?
Which honestly is the favorite, it depends, is the favorite lawyer question. So maybe we'll see how many lawyers are on the phone today by the response to that question. So we'll wait for a few more to get submitted, and then we'll show you the answers.
Okay, so, sorry, there we go. So it looks like most of you have selected it depends, which of course is the correct answer. So in sort of analyzing this situation, the first thing to think about is, were the soccer tickets given for a corrupt purpose? So did Dean USA give them to Dean FSU in an effort to influence him? And so based on the facts that we have, probably not, but maybe. We don't know. We need to consider whether the tickets were given to build goodwill so that they're joint, or were they given to ensure that the program would continue?
And I think that's really important, Lisa. I mean, is the program about to expire and needs to be renewed? And the other thing that I came up with the it depends is who paid for them. I mean, is that going to be a business-related expense that's going to be reimbursable, or is it truly a friendship gift in which it was, given in friendship? So that was another thought that I had.
And I think that's a really good point, because if it's something where the dean actually tried to get a reimbursement from his university, that's pretty much a red flag. But if it's something that was just given truly out of friendship, they enjoyed working together, it's probably okay. Okay, so our next point, our next element is that under the FCPA, it is illegal to pay anyone, again, this is only for a corrupt purpose, so this would include a foreign official as well as the agents or an intermediary of a foreign official. So that could be an assistant, a spouse, an advisor, anyone of that nature. But again, this only applies when the institution knows or should know that all or part of the payment will be passed to the covered official.
I think that's a really good point too, Lisa, that you made, is that it's the should know. So you do have some due diligence requirements. You've got to try to find out. You can't bury your head in the sand and say, oh, we didn't know, so therefore we can't meet, the elements of this type of either civil or criminal liability because we didn't know. You do have some should have known requirements to try to figure things out and what's going on behalf of your institution.
That's exactly right. I mean, you cannot do something where you're ignoring what are obvious signs, like you said, sort of just, willful blindness, so to speak. So as an example of that, we're going to do a flashback to a very popular comic strip during the 1990s, which was Dilbert. And so this sort of gives an example of when this knowing element applies. So for those of you who remember, Dilbert in the comic strip works for the company that frequently outsources their work to the Republic of Albania. And so in this comic strip, you see that there's an attempt to bribe the Albanian Minister of Mud. And it's sort of complicated in terms of what they sort of configure in an effort to make this bribe happen. And once they say that they're going to just leave some money by the statue of the monkey god. But here we understand that sort of the bottom line again is that you know or should have known, and that here, even in this example where they have this elaborate scheme, it's clear that even though they're still indirectly trying to make an effort to have a bribe, and that would be an FCPA violation. So under the FCPA, the bribe ultimately must be presented to the foreign official. And so it's important to understand exactly what this covers. So based on a broad definition, a foreign official can be found at any level of foreign government. So it could be someone who's a very high-ranking official or someone who's more of a ministerial or lower-level official. It's very broad in terms of what it covers. And it also covers any instrumentality of a foreign government, or in other words, an instrument of the foreign government. And what's interesting about this is, or makes it more complicated, is that the FCPA, even though it uses this terminology of an instrumentality, it never defines what it means. And so they're saying that, for example, a bribe to an instrumentality of a foreign government could be a problem, but they don't explain what that means. And so to understand that, the only information we have are some regulatory guidance as well as a test that was put forth by the 11th Circuit Court of Appeals. And so this is a control factors test, and this slide lists what those control factors are. So for example, if your institution is entering into a partnership with a medical center in a foreign country, it would be important to assess who controls the medical center under these control factors. So does the foreign government, for example, subsidize the medical center? So if so, then that could be a sign that the medical center is considered an instrumentality of the government, and so you need to be very careful in your dealings with it. Another way of determining whether an entity is an instrumentality of a foreign government is to consider what's called the government function factors. And these are similar to the control factors and in some way overlap, but they're listed here on this slide. But essentially you're looking at whether the entity is performing a government function. So back to that medical center example, you would need to consider whether the public or the government generally perceives the medical center as performing a government function. And so that would be something that you would consider when you're trying to determine whether or not you're actually interacting with an instrumentality of a foreign government. So another way of looking at that would be to sort of consider this scenario. So Research University would like to enter into a clinical research agreement with University of Foreign State. Is University of Foreign State an instrumentality of the foreign state? So things to consider would be UFS considers itself a private institution. UFS is not classified as a government agency. 44% of UFS funding is received from the government. UFS employees are not eligible for government employee benefits. The governing board of UFS is appointed by the King of Foreign State. However, the governing board appoints all senior administrators. And it's the only university in foreign state, and UFS's mission is to educate the people of foreign state. And so here you see that there's a variety of factors if you were doing this type of analysis that could go either way if you were trying to determine whether your interactions with this university could be subject to the FCPA. And so, for example, under the control factors in this instance, the fact that the king appoints the governing board could arguably give the king control over how the university is governed. And so that would seem to say that it is an instrumentality of the government. If you looked under the function standards that were just on the last slide, because University of Foreign State is the only university there, and it receives 44% of its funding from the foreign state, again, those seem to indicate that it is an instrumentality of the government. So sort of the bottom line is, if you're interacting with an entity overseas, don't just simply say, are you an entity of the foreign government? You need to sort of do that analysis of yourself. They may not consider themselves to be so, but they may actually, the U.S. government, for purposes of this act, might consider them to be. The other thing is that oftentimes colleges and universities, when they're working abroad, they're doing so in partnership with healthcare entities, maybe having programs with hospitals overseas, things of that nature. And generally speaking, whenever you're working with a hospital or health system, those generally are considered instrumentalities of a foreign state. Again, you need to do the analysis, but most often they fall within that definition. This became an issue for the company Pfizer, the pharmaceutical company. They ended up paying a $60 million settlement. And as part of that, the Department of Justice put forth some guidance that basically said, generally speaking, oftentimes when you're dealing with a hospital or a healthcare center in a foreign place, those often are covered by the FCPA. So we were talking about whether someone's an instrumentality of, or an entity is an instrumentality of a foreign government, but also it's important to understand who's included as a foreign official. And so that's defined extremely broadly under the Act, but it could be, again, administrators and faculties at state universities, advisors, members of committees or panels. It could be a political candidate. So really consider who you're interacting with. Are you meeting with a member of a royal family? And again, it could be anyone at any level of government, not just a high-ranking official. So it does not apply just when you're in the foreign country. It also applies, let's say, if a foreign official comes to your university. So it's not just to think about this happening when you're elsewhere, but also if you have someone from overseas visiting you, be sure to make sure that there are no violations of the Act. So again, the FCPA prohibits any attempt to improperly influence a foreign official in order to obtain, retain, or direct business to your university for your advantage. So you really need to be careful, as Haley was saying at the beginning of this. This often comes up when you're seeking approvals to operate academic programs in foreign countries, when you're seeking to receive permits or licenses because you want to start a new facility, or if you're trying to secure a visa for your students and employees, and maybe you're dealing with a slow-moving government. So really be careful because it's very broad. It applies anytime you're doing something to really assist your institution. So you need to be careful in terms of the different instances in which this may come up. Okay, so now we're going to move on to, I'm going to talk about the enforcement of the Act before turning it back over to Haley. So as Haley was mentioning, for a long time after this Act came into being in 1977, there wasn't a lot of activity, but then it really, over the last few years, has really ramped up. So in case you're wondering, well, why should I or why should my institution care about the FCPA, the answer is just that the enforcement of it really was stepped up starting in the Bush administration and then even more so in the Obama administration. And this slide really shows what the potential penalties are for institutions and individuals under the Act. So for your institution, for example, it could be subject to fines up to $2 million for each violation. Also, it could hurt your ability to participate in Title IV because if your institution is found to have violated the Act, it could influence your ability to have agreements with the government. And for example, settlements during 2016 under the FCPA range from $46,000 to $3.5 billion. And so some of these were publicly traded companies with a global reach, but it just goes to show that the amount that can be to penalize an institution can really vary. Also, the Act applies to individuals, and this is personal liability. So your university or your college would not be liable. The actual individual would have to be liable. Fines up to $250,000 and up to 5 years in prison for violating this. So it's very important to understand what the potential penalties are. To date, the FCPA has not been enforced against a nonprofit entity, but the Department of Justice has made clear that it absolutely does apply to nonprofits, and they state that clearly in their guidance. So all institutions are covered. So one of the questions now is that now that we have a new administration, whether a Trump administration will be as vigilant as the Bush and Obama administrations were in enforcing the FCPA. And this is not something that Trump talked about during his presidential campaign or since he's been in the White House. So the only information we have to go on is that in 2012, he did an appearance on CNBC in which he stated that he thought the FCPA was an outrageous and horrible law. And so that seems to indicate that he may not be interested in enforcing it. He said that at that time, he said that he thought it was ridiculous that the United States would criminalize actions that occur abroad, and he suggested the United States should focus on what happens within the U.S. and allow foreign countries to manage what happens in their own countries. So based on those 2012 comments, anti-corruption activists have really been speculating that President Trump may work with the Republican Congress to limit funding of the FCPA enforcement. And since he's been president, which hasn't been that long, there haven't been any settlements or anything of that nature from either the Department of Justice or the SEC related to the FCPA. So we're really in a wait-and-see mode. But assuming that it does continue to be enforced, things to know that if ever a claim is made under the FCPA against your institution, there are exceptions and there are affirmative defenses. And so the first one is an exception for facilitation payments, which are also known as grease payments. So grease payments are essentially, they're small payments that are made to low-level officials in an effort to expedite or secure the performance of what is a routine government action. So the key here is that the payment amount must be small. That's the first thing. And the second thing, the payment must be for a routine action that the government official is otherwise obligated to perform. So for this exception to apply, the government official must be doing something that's a part of their normal job. So for example, issuing a permit, if that's something that they already were obligated to do, a grease payment could be something to consider in that scenario. So the other thing, though, to keep in mind is that while the FCPA allows for these grease payments, the actual country where this is happening or the official that's governed by their own country's law, it may not accept these kinds of payments. So it's important to know what the law also is of the country in which you're operating. So here's a hypothetical. While overseeing the launch of a branch campus in foreign land, you learn that property deed for the campus must be officially filed by the Office of Deeds. However, there is a backlog in the Office of Deeds which could delay the launch by 6 months. You learn you can expedite the filing by paying a one-time small payment to an administrative assistant in the Office of Deeds. You make the payment. Is this a problem under the FCPA? So we will do another poll question here. So the question is, does a payment to the administrative assistant violate the FCPA? The first answer is most likely it is a violation, or the second answer is most likely it is not a violation, and we will give you a minute to respond.
Of course, this time we didn't give you an it depends, so you actually have to pick this time a violation or not a violation. So it looks like we have some that are coming in. That's good. Hopefully we can get a few more, and then we'll show the responses.
Okay. There it is. So the answer is the second, which is the answer is most likely it is not a violation. Although I have to say, I can see why some people thought it most likely it is a violation. It sort of feels like it could be a violation, but it actually most likely is not. And so this payment most likely qualifies as a facilitation payment as long as the filing of the deed is something that this administrative assistant was already obligated to perform. So this is the kind of thing that would qualify as a grease payment. However, sort of as a best practice, before making a payment similar to this, we highly recommend that you talk to your office of your general counsel or your legal counsel, whoever you have, as well as your local legal counsel. Because again, maybe in that particular country, it would be a problem. The other thing is it's really important to document any sort of payments. I know Haley will talk about that later in the event this becomes a problem. So another exception is that a defense to a claim that you're violating the FCPA is that the amount of money that you're spending is actually a reasonable and a bona fide expense. And so, for example, on this slide we talk about University USA, as part of a collaborative project with University China, may be obligated to pay for foreign professors or staff to travel between project sites or to attend events that serve as training or educational purposes. So that's the kind of thing that would be a reasonable expense, especially if the amount spent is reasonable for what they're doing, because it's for a legitimate purpose, for training and educational purposes. One of the areas that is often under scrutiny under the FCPA are travel expenses. So sometimes when an institution or a company wants to say, hey, look, this wasn't an FCPA violation, these were reasonable expenses that are for legitimate purposes, that has sometimes been called into question. And so these are two examples. So UT Starcom ran into trouble because they paid $7 million for training trips and location where they didn't even have facilities. And then also Lucent Technologies ended up paying a $1 million penalty for funding trips for Chinese officials that were supposed to be related to inspecting factories, but actually they were for sightseeing activities. So again, the bottom line is really to avoid extravagant expenses and also to make sure that they meet a legitimate purpose.
And we're not saying that you can't have any type of, for foreign officials visiting the United States, you can't do anything outside of just going back and forth to an office. That's certainly not what we're saying, but it has to be, again, that business purpose has to be tied to, and I think these two examples show that there really was no business purpose other than to provide a free trip.
I agree, and I think the key is that you want it to be reasonable. If you have a foreign official come and that person does a presentation, and then you all go out to dinner later, and it's a reasonable dinner, it's not a gazillion dollars, and you're debriefing on what happened, that's appropriate.
Yeah. Or I had another client that asked me a question of the foreign official had come, made a presentation, and they wanted to show the foreign official a little bit about the state and took the foreign official to the state fair. Well, there's an entry fee for a state fair, and obviously a Twinkie on a stick costs something, but those are cultural experiences that were reasonable in nature to provide some other benefit and not for a purpose that was corrupt in nature, that it was an intent to try to get them to make a decision.
Exactly. So those are the things that don't fall into, that are not a problem. One last thing that also is not a problem is that if you're doing something that is to promote your institution's services, or it's part of a contract that you've executed. So in those instances, as long as the amount spent is reasonable and they're for a legitimate purpose, it's okay. And so the Department of Justice has actually said that in those instances, those are things that you can do. So with that, I'm going to turn it back over to Haley to talk about how to comply with the Act.
All right, so we're going to lay out for you, essentially, as we talk about FCPA compliance, what are really the 6 steps that you should be taking to make sure that your institution is in compliance. And the first step is to make sure that you have a comprehensive policy. And this is really important, to make sure that your institution has a clear policy that addresses anti-corruption laws, and that you keep the policy broad. It's not solely focused on just the FCPA. The other thing that I would encourage you to do is look at your current policies and see where you already have some of these statements listed. So you may have an employee code of conduct. You may have a gift acceptance policy at your institution that you already use. You may have an anti-bribery policy. You likely have a nepotism policy. All of those things could go into compliance with the FCPA, but when they're kind of spread around the institution and not put together in a comprehensive package or linked, as we've seen as the best practice, really get things to link to, back to your nepotism policy, but mention it within this type of comprehensive policy. That's really the best practice that we've seen. So make sure, you should be, hopefully you know your institution's policy. If you're not sure, ask if your institution has a policy, because most institutions now are doing, work overseas. They are recruiting students overseas. They are having joint agreements. They are, even some of them, quite a few of them honestly, have campuses that are overseas. And so you need to make sure that you are in compliance and have that policy in place. All right. The next step in terms of the policy compliance is, in that compliance, you need to make sure you address this bookkeeping and accounting controls. So make sure that you have internal controls laid out in terms of how you're going to deter corrupt practices. So if you're going to have payments, who approves the payments? And how does that work in terms of the approval process? And do you have, I've seen some schools that actually have a form attached to the payment for the foreign payments of what it was for. They went, through kind of detailed questions to really talk about, is this an appropriate payment, and does it need further review? Do you need to go to your outside counsel, if that's who you use, or your internal general counsel, and make sure that these payments are important? So strong bookkeeping practices are really, really important for compliance with the FCPA, and making sure that, again, those policies are outlined within your compliance policy, your overall broad policy of how you're going to document the payments, how you're going to make sure those reimbursements are appropriate, and those internal controls that you're setting. There's really not a one-size-fits-all approach when you're doing this. However, there are a couple of really good examples that I'd like to tell you about. And There's a couple of people at these institutions that put out a lot of information on the FCPA, so if you're looking for additional information, they are excellent resources, and Lisa and I even read their materials as we were preparing for today and had a lot of helpful content. The first is Alyssa Greenwald, and she is at Yale University, or was at, I think has continued at Yale University, but they have the Yale International Toolkit, which has a lot of good information. And the second is Daniel Munch, and he's at Carnegie Mellon University. Their FCPA policy and guidelines are very, very good. So if you're looking for a starting point, their policies are extremely comprehensive. It may not be everything that you need. It may not be exactly what you need at your institution, but it's a good starting place to look at if you're looking for where do we just get started with our compliance policies. The second step is after you've got your policy, and this should be determined under your policy, but who's responsible for compliance? So making sure that it's a high priority at your institution and that there's a clear allocation of responsibility. Who is the person that's going to be held responsible if things are not done correctly? And that's one thing we see a lot with FCPA compliance. No one really knows. There's usually a director of international students or international affairs, and then there's a vice president potentially over them. So no one really understands who that is. So make sure your policy addresses the responsibility. Ideally, that person would be accountable for the ethics of the academic programs and interactions with foreign officials as well. So that would be an ideal situation, but it's up to the institution. Again, there's no one size fits all. You can make those determinations yourself, but make sure you really have buy-in at the administrative level and who is going to be ultimately responsible for compliance. Step 3 is you've got to assess your risk. So you've got to, what are the things that we're doing in foreign markets, in foreign countries? What are the steps that we're taking to recruit potentially foreign officials to come to our campus? You need to understand what your risks are. So that starts by looking at cultural issues. So in those countries, are there cultural issues that you need to be aware of? Determine when you do have those direct or indirect contact with foreign officials, and specifically, Lisa highlighted this, but I just want to say it again, in the area of health science, when you're looking at medical programs, nursing schools, other types of health science programs that you're offering overseas or that you're partnering with, a lot of those are part of a foreign government, and you may not be aware of that. So make sure you're assessing that as part of your compliance. And then looking at the biggest area of potential liability is third-party contact, determining who's going to be acting on your behalf, and have you appropriately trained them? Do you have a contract in which you can inspect their books so that you know when they're making payments on your behalf? And because, again, they're out there, for lack of a better word, as your agents in that country representing the institution. So it's really important that you assess your risk and that you do due diligence. And we're going to talk about that due diligence that you need to be doing. So here's some DOJ red flags and some of their communication. A history of corruption in that country is a red flag. Involvement by government officials or with close ties to government officials can be a red flag. Requests for payments to third parties or out-of-country destinations, high commissions, all of these types of things when there's an inadequate record keeping. So if you don't have a contract, you're not inspecting or having any type of audit process, those are all red flags for the Department of Justice in terms of enforcement. So when you're doing your assessment, I think it's important, there's the Corruption Perceptions Index, and we pulled the 2016 index. This is a really good tool when you're trying to determine whether corruption may be a concern. And so looking at this tool, it's the Transparency of International Corruption Perceptions Index, and it scores countries based on the public sector corruption. And so it has a score. If you are in the red, the dark red, that means that you have a high level of corruption. If you were in the really bright yellow, it means you have an extremely low level of corruption. So scores below 50 show serious corruption within those particular countries. So we just picked a few examples for you. When you're looking at your risks, we picked Uganda and Canada. So Uganda ranked 115 out of 151 out of 176 with an overall score of 25. So there was a lot of examples of corruption in Uganda according to this survey. And if you're going to be doing work in Uganda, if you're going to be opening a school, partnering in Uganda, you want to be aware that the risk levels for FCPA issues are going to be potentially higher for you. Another example is our neighbor to the north, Canada, ranks 9 out of 176 for the countries that are in this assessment, and had a score of 82 out of 100. In case you're wondering, the United States ranks 18 out of 176 for corruption and got a score of 74 out of 100. Denmark and New Zealand are tied for number 1 on the index. So, and as of 2016, Somalia was the worst ranked according to the study. So that gives you at least a tool as you're doing your assessment. So again, best practice is that you look at what your institution is doing, you look at what's happening with the culture in those countries, what could be the perception, to make sure that you will have a high level of due diligence as you're looking at contracting with third parties that are going to be representing you in those particular countries, and that you know those countries' laws as well. So next step in assessing risk is to make sure you have training. Who is representing the campus, representing the institution in that foreign country, and have they been trained? Do they know what your policies are? Have they agreed to follow your policies? And we would love to see that you have records of training and certifications that all of these employees or agents or third parties have signed off that they're going to abide by the FCPA, they're going to abide by your policies and any local laws or countries that have their own anti-bribery statutes as well. So having that training program in place is extremely important. Some schools have decided to do, put this information on an online training platform. That's worked well because I understand that there can be some turnover, and so you're contracting with third parties and you're having turnover, but it's a way for you to try to protect yourself, as Lisa said, if you have somebody who's trying to say that your institution through a third party did not comply with the FCPA. And then the other thing I really wanted to focus on was due diligence. So make sure that you're asking questions. So why are you hiring the agent? Are they necessary? What are the agent's qualifications? What are the references? So if the references, the Minister of Education referred us to the agent and told us we had to hire in order to get our program going, that's not going to fly under the FCPA. You need to make sure that you're doing some due diligence. Do they have any red flags that are raised? So is the agent saying they won't sign the contract or they won't conduct the training? Those are red flags that you would see from the beginning. So you have a responsibility as an institution to do third party. We like when we have a third party agent screening questionnaire that has these specific questions that they have to answer. Now, obviously, in foreign countries, you need to make sure that they're translated into their language, and that's important for the policy as well, that the policy is translated into multiple languages if you're conducting business in multiple countries as well. Step 5 is to make sure you adopt and implement those requirements for third parties. So make sure that you are very clear with your requirements to hire a third party, and that you have in your contract that they are going to comply. Not only that they're going to comply, but if you can get it in the contract that they're going to indemnify the institution if there are any FCPA fines or penalties. I think that's very important as well. The contract should also include audit rights. As I stated earlier, you need to be able to go in and look at the books, and you should be working with counsel in that country as well as your own U.S. counsel as well. They may identify other terms that you may want to have in your third-party agreements, third-party agent agreements, to make sure that you are protected. And then the last step is to continually assess. The FCPA, it's not just putting these pieces in place and then walking away and saying, well, we're in compliance. You've got to continually determine what has changed. Are we using different third-party agents or agreements? How are things changed in that particular country? Lots of things have changed, especially in recruiting of international students. So this is a good time to look at those agreements that we have and make sure that you're in compliance. There's a lot of pressure being put on at least those companies that were recruiting and sending a lot of students over to the United States, and now with immigration issues or visas not being as quickly issued in some countries, or even honestly some countries are fearful of travel. All those things can put pressure on people to try to skirt the line to make sure that their visas go through the process quicker. So I think it's important to continually assess and make sure that you are looking at these issues definitely on an annual basis, but I would say you want to even look at it at a quarterly basis as well, and making sure you're checking these boxes even if you have all of these steps in place at your institution already. Other laws, again, there's a lot of other laws in other countries that have anti-bribery laws. So I just mentioned a few of these on the slides. But if you're in another country, you need to make sure that somebody is looking into their laws and that we're complying with their laws as well. So with that, Lisa, I think we are out of time. So I think a few people have submitted questions. We will go ahead and do email responses to those questions and get those back to you within the next couple days. We appreciate you being on the webinar. Thank you for participating in our program today. We hope that it was helpful for your organization. Again, a basic review of the FCPA. If you have not already, please click the survey icon at the bottom of your screen and complete a short survey. This assists us with providing future quality programs. We really love your ideas for webinar topics. And if you're joining us for the first time today, we have monthly webinars offered for continuing legal education credit and general knowledge of other topics as well that are offered through our Husch Blackwell education group. So thank you again. As a reminder, this program has been approved for CLE credit in Colorado, Illinois, Iowa, Missouri, Nebraska, Tennessee, and Wisconsin. If you're in Illinois, Nebraska, and Tennessee, make sure you click on that CLE icon now and fill out your information so that you can get credit for attending, and a recording of this webinar will be available tomorrow for watching and sharing. Once available, you can forward on the link as well. This concludes our webinar. Thank you so much for attending.